Notice to cease and desist all administrative bonding. Private notice under seal for cause and necessity. From a living man woman, standing in full capacity, not a corporate fiction care of non-domestic, non-resident, without the United States on the land known as. 2. All officers, agents, bar attorneys, fiduciaries, trustees, judges, clerks, sheriffs, municipal officers, and bonding entities acting under or within United States Corporation and its subdivisions, including but not limited to state of, county of, irrespective department. Subject: formal demand to cease and desist all administrative bonding activities pertaining to the legal person. Construct your name in caps. Declaration of status and standing. Be it known to all agents, officers, and presumed actors operating under color of law or commercial fiction. I, the living man, woman known as being of sound mind, full age of majority, and competent in all respects, do hereby declare and record my status as a living soul and private American national. I am not now, nor have I ever knowingly, willingly, and intentionally consented to be a surety, trustee, or debtor for any artificial legal entity created by or for the United States, state of, or any of its instrumentalities. I am not a U.S. citizen or person as defined under 14th Amendment statutory constructs, nor am I subject to any commercial contract, military, code, civil adhesion trust, cestuikv estate, or administrative venue constructed without full disclosure, mutual consent, and lawful authority. All administrative presumptions made through the issuance, sale, or securitization of bonds, CUSIP-registered instruments, or other financial instruments tied to the entity styled in all capital letters are hereby rebutted and denied ab initio, nunc pro tunc. The burden of proving jurisdiction rests upon the party asserting it. It is never presumed. American Jurisprudence, Vol. 16, SS 97. This notice shall serve as a declaration of living status and a lawful rebuttal of all presumption of joinder to the artificial construct. Further, I assert my natural and equitable rights as a man-woman of the soil, protected under natural law, the law of nations, the organic Constitution for the United States of America, the Bill of Rights, and the principles of equity and justice. Ecclesiastical trespass and canonical breach. The unlawful bonding and securitization of a living soul through the issuance of a legal fiction and the creation of constructive trusts constitutes a grave ecclesiastical trespass, a violation not only of equity but of sacred canon law, natural law, and divine order, papal authority and trust structure. It is widely known, and not rebutted by the Vatican or any ecclesiastical authority, that the Roman Pontiff, acting as trustee of the world under the papal bull Unam Sanctum, established the first express trust-claiming dominion over all human souls and temporal property. This trust formed the root of the three-tiered cestuikv trust structure. 1. Real property, seized at registration of birth. 2. Personal property, bonded via birth certificate securitization. 3. Ecclesiastical, sole property, claimed at baptism. These constructs, though framed under ecclesiastical and Roman law, were never disclosed to the living beneficiaries, and no lawful, knowing, and willing consent was ever given. For a perpetual remembrance, repeated phrase in the testamentary papal bulls. The continued use of these presumptions against the living man-woman without rebuttal constitutes not only a fraudulent trust, but a breach of canon law, including Canon 2056, no ecclesiastical authority has any lawful jurisdiction over a living man without explicit voluntary submission. Canon 3228, the grant of baptismal certificate does not imply grant of soul, unless such grant was made knowingly and willingly with full understanding of consequences. Therefore, I formally rescind, revoke, and rebut all claimed ecclesiastical authority, trust administration, or soul harvest mechanisms imposed upon me or my estate. All attempts to administratively reap the spiritual essence or life force of a living being through bonding, securitization, or baptismal title transfer without full disclosure is hereby declared null, void, and a high crime in both spiritual and temporal jurisdictions. I invoke the right of ecclesiastical reclamation and declare all claims against the soul, body, and spirit of this living man, woman to be fraudulent, malicious, and spiritually void. Trust collapse and commercial dishonor. Once fraud is discovered, equity demands remedy. No trust testamentary, constructive, implied, or express may lawfully stand once its foundation is proven to be fraudulent, lacking full disclosure, or maintained through coercion or presumption. A. Collapse of constructive and cease trusts. In accordance with equity maxims, trust collapse occurs when a grantor or presumed grantor was never informed of the trust. Beneficiary is also the rightful owner of the res property. The trustee fails to act in good faith or violates fiduciary duty. Presumption of death, incompetency, or abandonment is rebutted. Amjur 2D, Trust $23. A trust may be terminated where its purpose has been fulfilled or is impossible of fulfillment, or when its continuation would be unlawful or contrary to public policy. The presumption that a living man or woman is lost at sea under maritime salvage law, and thus subject to constructive trust administration, fails upon the living man's appearance and rebuttal of abandonment, incompetency, or consent. Declaration of life, claim of the estate, and denial of presumed death or incompetency. Collapses all three cease trusts issued at birth, bond, and baptism. Discharges the implied contract under the Uniform Commercial Code, especially UCC 3603. B. Commercial dishonor by public agents. The continued operation of legal or commercial claims after proper rebuttal constitutes dishonor in commerce, a breach of UCC trust obligations. Authority cited: UCC 1-308, Reservation of Rights. UCC 3-501, presentment must be met with proof of claim and authority. UCC 1-103, common law and equity are preserved under UCC unless displaced. A trust operating on unrebutted presumption becomes void for fraud when challenged and not defended with evidence. The continued enforcement of said trust is a tortious conversion of estate property and breach of fiduciary duty by officers of the court. Commercial war crime under the Geneva Conventions and Hague Protocols when administered against civilians or non-combatants. Living man-woman issues lawful notice of collapse, and all claims, securities, or encumbrances associated with the name or estate constructed via fiction, fraud, or non-disclosure are hereby collapsed. All agents attempting further enforcement are acting in dishonor, fraud, and bad faith, and are hereby noticed and liable. Canon law reassertion and return to the living. At the heart of all Western law, including civil, commercial, and ecclesiastical, is canon law, the spiritual law of the Roman Catholic Church. The papal bulls, foundational to Vatican governance, set forth the system of claims over land, body, and soul via trust instruments. The return to the living status requires rebuttal and counterclaim against these canonical presumptions. A. Hierarchy of law and canonical primacy. Canon law is the highest private law system recognized globally due to, when its foundational trust structure based on the Unum Sanctum Papal Bull, its administration over international personhood through the three cease trusts, and its enforcement through ecclesiastical courts, state bar actors, and maritime admiralty overlays. According to Canon 2057 and related canons, no trust may survive fraud. A trust founded upon deceit or lacking full knowledge of the grantor is void ab initio. This is further affirmed in ecclesiastical jurisprudence. Canon 2046, an act against conscience is null. Canon 2043, false claims through concealment of fact are frauds upon the law. B. Restoration through notice and rebuttal. To return from the status of dead at sea, the living man must 1. Rebut the presumption of death, incompetence, or lost status. 2. Reclaim dominion over their name, estate, and spiritual title. Notice of resurrection the lawful and living status under. In canon law and trust law, this takes the form of ecclesiastical notice of status, living testimony of life and status correction, and claim of the divine trust, asserting the living soul's title under God's law, not man's fiction. C. Return to lawful standing. Upon completion of rebuttals, the man or woman stands outside of maritime jurisdiction. The Vatican's claim over body and soul is rebutted. The executor de son tort, that is the judge or bar agent acting without consent, becomes personally liable. Thus, The living man or woman, once presumed dead, now reasserts status as beneficiary and grantor of the estate, soul, and trust, denying all false offices operating by presumption, license, or fraud. This process is further supported by Canon 96-97, asserting capacity and legal personality only with consent. Canon 145, authority must be conferred validly and licitly without fraud. Canon 2034, where fraud is present, all subsequent acts are void. Ecclesiastical notice and enforcement of liability. Incorporating Canon 2057, fraud nullifies trust. Canon 2057, foundation for voidance of fraudulent trusts. Canon 2057 of ecclesiastical law states, a trust or obligation created through concealment, fraud, or without full disclosure of material facts is null and void ab initio, and all rights, claims, and derivatives arising therefrom are forfeit. This canon is the ecclesiastical sword against all fraudulent presumptive trust systems, particularly those that create sestui kv trusts under conditions of lack of informed consent at birth, presumed abandonment or death, on coercion via adhesion contracts, commercial conversion of natural rights. Canon 2057 reaffirms that any legal instrument created through misrepresentation is null. The Vatican or Crown cannot assert valid title over a soul, body, or land derived from fraudulent premise. All agents, judges, clerks, and bar attorneys acting under such fraud incur ecclesiastical liability and personal dishonor. Serving ecclesiastical notice, rebutting false. A formal ecclesiastical notice of rebuttal must be served upon the Vatican, relevant Crown, UK, Spain, etc., depending on the papal, the Bar Association, the local judge or clerk. This notice must 1. Rebut all 3 CQV trusts. 2. Reference Canon 2057 to nullify the creation, maintenance, and benefit of such trusts. 3. Assert the living status and deny any implied consent to be governed or bonded. I, a living man-woman, being of sound mind, not a corporation, minor, or ward of the state, do hereby nullify any and all trusts presumed to be established in my name under concealment, coercion, or fraud, per Canon 2057. C. Liability of the executor de son tort. An executor de son tort is someone who acts in the administration of a trust or estate without lawful authority or consent. Under ecclesiastical and trust law, judges, magistrates, clerks, attorneys, and state actors who enforce fraudulent legal presumptions upon the living incur personal liability. Canon 2057 makes clear these actors, if continuing to enforce known fraudulent trusts, become subject to ecclesiastical rebuke, financial liability, and divine judgment. Supporting citations. Canon 1461. No one may exercise public office who does not lawfully hold it. Sound Canon 1321 SS 1-2. Ignorance does not absolve one who had the duty to know. Canon 221. The faithful may lawfully defend their rights before the Church. D. Lawful remedy initiated. Once notice has been issued and rebuttal entered into the public and ecclesiastical record, all bonds, securities, and instruments tied to the CQV trusts must be ceased. The presumption of consent to commercial governance and legal death is lawfully voided. The living man, woman reclaims full equitable and legal title over their name, body, estate, and soul. This establishes lawful dominion under natural law with ecclesiastical immunity from civil process and standing as one who is no longer subject to presumption, constructive fraud through court bonding, and CUSIP conversion. A. The bonding mechanism, legal alchemy. Upon entry into a court system without rebuttal of jurisdiction, the living man or woman is presumed to be a corporate fiction and the estate. Trust is bonded under municipal finance rules. Key mechanism. The case number is treated as a bond or security instrument. The name in all capital letters is presumed a trust or estate. Numbers assigned via the court registry investment. The case becomes a financial product traded on domestic and international markets. Constructive fraud occurs when man or woman believes they are in a justice forum, but the court actors are actually operating in an administrative commercial proceeding for profit. B. Applicable statutory and financial references. 1. 31. USC SS 9303 governs surety bonds filed in federal courts. 2. Federal Reserve Act of 1913 empowers private issuance of credit backed by bonded instruments. 3. Trading with the Enemy Act allows seizure of enemy property. 4. Emergency Banking Relief Act extended corporate trust control over the population by executive fiat. These statutes are not laws in the constitutional sense, but commercial instruments enforcing bonding schemes through, when presumption, registration, adhesion, silence. See commercial conversion of rights into securities. Once bonded, the court's trust account is activated, and a performance bond is created based on the expected outcome of the case. These bonds are bundled and sold on secondary markets via DTCC, Euroclear, and others. This process monetizes your appearance and presumed guilt, and provides incentive to the court to proceed to judgment. Violates Canon 2057 and maxims of equity especially. No man shall profit by fraud. Equity regards that which ought to be done as done. Court officials as executors and trustees, judges, clerks, and prosecutors. When you do not act as impartial public servants, but as trustees or executors of a private commercial trust. They benefit from your lack of rebuttal, acting as executor de sun tort, to administer an estate to which they hold no lawful title. This amounts to breach of fiduciary duty, violation of canon law and trust law, commercial trespass against the living man or woman. If one acts as an executor without lawful authority, they assume full liability for the consequences. Trust law principle, lawful and ecclesiastical remedy for constructive fraud. To collapse this fraudulent trust and terminate the bond. 1. Living testimony of status and rebuttal of jurisdiction. Declaring living status and denying trust creation or assignment. 2. Notice of revocation of signature under duress and non-disclosure. 3. UCC 1 financing statement, securing the legal name and reclaiming commercial title. 4. Ecclesiastical notice of fraud referencing. Canon 2057, Canon 1321 SS1, Canon 1463, international treaties, and the violation of natural and ecclesiastical rights. A. Foundational treaties affirming natural rights. Multiple treaties binding on the United States reaffirm that natural men and women possess rights prior to and superior to any statutory or corporate authority. These include 1. Treaty of Peace and Friendship. Recognizes non-commercial, non-combatant nationals as peaceful and outside foreign jurisdiction without consent. Establishes that those not engaged in acts of war or commerce retain their own law and protection. 2. Geneva Convention 4, Protection of Civilians. Article 4, civilians shall not be treated as enemy combatants or subject to martial military jurisdiction. Article 147, unlawful confinement, taking of hostages, and forced administration are grave breaches. 3. Universal Declaration of Human Rights. Article 6, every human has the right to recognition as a person before the law. Article 15, no one shall be arbitrarily deprived of nationality. B. Ecclesiastical and canon law prohibitions. Canon law, the governing legal system of the Vatican and foundational to Western legal development, explicitly prohibits fraudulent jurisdiction and unconsented trusteeship. 1. Canon 2057, fraud vitiates all. Any trust, contract, judgment, or presumption founded upon fraud is null and void ab initio. 2. Canon 1459 SS1. A judge is obliged to withdraw from trial if a legitimate suspicion of conflict or impropriety exists. 3. Canon 1321 SS1. No one is punished unless their violation is deliberate and willful. Silence due to concealment or presumption is not lawful consent. 4. Canon 1498. Every cleric or officer must have proper title and cannot exercise authority without it. These canons reflect the superior jurisdiction of divine and ecclesiastical law. Courts today, under colorable military or corporate jurisdiction, violate all of the above when presuming citizenship without valid contract, forcing men and women into foreign administrative law, and monetizing their estate or soul under ecclesiastical false title. C. Breach of international and ecclesiastical norms by the United States. 1. The War and Emergency Powers regime classifies the domestic population as enemy combatants under Trading with the Enemy Act, despite peace treaties. 2. Courts operate under Lieber Code and martial law norms. These are meant for war zones, not for civilian courts. The use of CUSA bonding and court monetization is a commercial practice in violation of human dignity, ecclesiastical rule, and treaty obligations. The true nature of proceedings, commercial not, fraud and inducement, fraud in factum, and a direct breach of international due process rights. D. Remedy under treaty and ecclesiastical authority. Any man or woman may assert protections under Geneva Convention 4. Standing as a peaceful inhabitant per the Treaty of 1787, and lawful objection to fraud-based ecclesiastical trusts under Canon 2057. Demand that no proceeding may continue without proper jurisdictional evidence, consent of the governed, and disclosure of all commercial interests and parties. The judiciary's failure to honor these treaties and canons makes it an accessory to ecclesiastical trespass and a belligerent entity against peace. Declaration of status, ecclesiastical testimony of fact, collapse mechanism for unlawful trusts and ecclesiastical reclamation. A. Trust law basics, valid trust requirements. Under both common law and ecclesiastical law, for any trust to be valid, it must meet the following essential elements. 1. A competent settlor, grantor, one who knowingly and voluntarily creates the trust. 2. A clearly identified beneficiary, one who receives benefit voluntarily and with informed consent. 3. A competent and impartial trustee with a fiduciary duty to the beneficiary. 4. Lawful purpose, not in violation of natural law, divine law, or constitutional protections. 5. Full disclosure and voluntary consent, without coercion, deception, or fraudulent inducement. If any of these are absent or violated, the trust is null and void ab initio, and subject to collapse upon challenge. B. Cestuica v. Trusts. Collapse by rebuttal. The three-tiered Cestuica v. Trust system, ecclesiastical, territorial, and commercial, is sustained by presumption of death or abandonment, lack of standing rebuttal, lack of lawful notice to trustee, administrator, to collapse a CQV trust created in your name. 1. Rebut the presumption of death. 2. Establish beneficial interest and living status. Claim your equitable and beneficial interest as the living man, woman, not the corporate fiction. 3. Serve ecclesiastical notice of reversion. Notify all presumed trustees that the trust is fraudulent, induced under duress or without full disclosure, and thus void for lack of lawful intent and consent. 4. Assert canon law and treaty protections. Cite Canon 2057, Geneva Convention 4, and Universal Declaration of Human Rights. Demand cessation of administration under false pretenses. 5. Cease and desist and notice of liability. Issue formal notice to bar officers and agents that they are engaging in administration of a revoked trust without authority and may be individually liable for damages under equity and commercial law. C. Ecclesiastical process of reversion. Under ecclesiastical law, the living man or woman may reclaim their soul and estate through an ecclesiastical deed of reversion and reclamation, unfiled into public record, or served upon the pontiff or local ecclesiastical proxy. This notice must state, I, a living man, woman, do hereby revoke, rebut, and collapse any and all presumed or constructive trusts created in my name or estate, including but not limited to Cestuica v. Trusts. I reclaim full legal and equitable title to my body, land, soul, and name, nunc pro tunc, ab initio. D. Structural collapse, removal of standing trustee. Upon removal of consent, the trust becomes orphaned. Under trust law, a trust without a trustee or lawful settlor cannot operate. The administrative mechanisms collapse or must transfer lawful control to the beneficiary. UCC 1-308 and reestablishes the man or woman as the holder in due course. Full jurisdiction and equity in common law, bar against any further presumed authority or bonding. Constructive notice to all trustees and fiduciaries. This section provides the formal structure for issuing a universal and ecclesiastical notice to cease and desist all administrative bonding, fiduciary interference, and unauthorized trust administration over the living man or woman. It must be issued in proper jurisdictional and spiritual standing, canon, equity, and commercial law. A. Format of constructive ecclesiastical notice. Title: Constructive ecclesiastical notice of reversion, revocation, and cease and desist from all administrative bonding and trust interference. To all agents, fiduciaries, trustees, and administrators. 1. Notice is hereby given that I, a living man-woman created by the divine source, having full agency, mind, body, and soul, do hereby revoke and collapse any and all presumed constructive or undisclosed trusts, bonds, estates, securities, or registrations, including but not limited to O birth certificates, O CQV trusts, O baptismal registrations, O social security or slave bonds, O court case dockets and CUSIP instruments, O property title transfers into foreign crown jurisdictions. 2. I have never knowingly, voluntarily, and with full disclosure agreed to be administrated as a minor, ward, franchise, or surety for any artificial entity or corporate fiction bearing my name in all capital letters or any variation thereof. 3. I hereby issue formal cease and desist orders to all agents acting under color of law, including but not limited to members of the Bar Association, O judges operating outside Article 3 or equity jurisdiction, O court clerks monetizing my name or estate via CRIS accounts or bonding schemes, O officers, registrars, or administrators enforcing false jurisdiction via presumed contracts. This notice is universal, permanent, and binding. 5. I stand under divine law, natural law, and canon law 2057, which states, any attempt to use a living man or woman as collateral, surety, or chattel through fraudulent conveyance, non-disclosure or simulated legal process shall be considered a crime against the soul, subject to immediate ecclesiastical correction. 6. I declare myself to be the sole grantor, executor, and beneficiary of any and all trusts created in my name, nunc pro tunc, ab initio. All unauthorized agents are hereby removed. Any continued interference shall be deemed O tortious conversion, O ecclesiastical trespass, O commercial fraud, O and a war crime under the Geneva Conventions. Let it be known and entered into the universal record that I reclaim all spiritual, legal, and equitable rights, titles, and interests, body, mind, soul, estate, and dominion, from this moment forward. Enforcement and remedies for breach of notice and unlawful administration. This section establishes the lawful remedies, enforcement authorities, and pathways for securing reparation, restitution, and relief when administrative agencies, courts, or agents fail to heed the ecclesiastical, equitable, or commercial notices delivered in honor and good faith by the living man or woman. A. Canon law and ecclesiastical penalties. 1. Canon 2057 and 2058. Any use of a baptized soul or registered living being for commercial purposes without voluntary, informed consent is a high ecclesiastical crime. Unlawful use of a CQV trust, registration, or presumed estate amounts to forced servitude and trespass against the temple of the living God. Canon law remedy. Under Ecclesia Militans, the perpetrator becomes personally liable, spiritually damned, and their authority voided ab initio upon verified notice. B. Equity jurisdiction and trust law remedy. 1. Maxim of equity. Equity will not suffer a wrong without a remedy. 2. If a court or agent continues to administrate a living being under false identity, misappropriated trust instrument, fraudulent jurisdiction, or non-consensual adhesion contract, the victim may lawfully seek remedy by a commercial lien against the offending officer or agency, bringing suit for tortious interference, conversion, or breach of trust in a court of record or equity, seeking ecclesiastical excommunication and commercial lien enforcement through private tribunals or recognized assemblies. 3. Trust remedy. The living man or woman may collapse any presumption of a trust by then asserting themselves as the executor, noticing the court of fraudulent conveyance, and revoking consent in writing and by public record. See Commercial Enforcement under UCC and Lex Mercatoria. 1. UCC 1-308 allows reservation of rights in any transaction, denying presumed consent or waiver. 2. UCC 3-501 and UCC 3-505 permit refusal of presentment, dishonor of negotiable instruments falsely issued in one's name, and demand for verification. 3. Private administrative process, 3 notice method, 1 testimony of truth and fact, notice of fault and opportunity to cure, notice of default, estoppel, and final record of dishonor. This commercial method of remedy has universal standing in commerce and equity if unrebutted point for point. D. Remedies available. Untort compensation, civil damages for fiduciary breach or unlawful prosecution. And public record seizure, challenge fraudulent registrations in court and state registries. An international appeal, file with the International Tribunal for Natural Justice, UN Human Rights Council, or ecclesiastical courts. Common law assembly adjudication, bring action before peers in lawful tribunals not captured by admiralty jurisdiction. Public record filing, publication, and finality of standing claim. This section outlines how to give lawful force and international effect to one's ecclesiastical, equitable, and sovereign standing through public record filing, publication, and proper notice, thereby making one's rebuttals and declarations legally, commercially, and spiritually binding. A. Why public record filing is essential. Under both common law and international commercial practice, public notice creates legal presumption and binds parties who do not rebut the record. Silence, after opportunity to respond, equals consent and agreement. Therefore, to give force to your declarations, 1. You must publish and file your O status correction, O ecclesiastical testimony of fact, O revocation of assumed citizenship, O claim of right, O cease and desist orders, O ecclesiastical reversion of soul and trust. 2. This turns a private declaration into a recognized claim, rebuttable only by sworn testimony point for point under penalty of perjury. B. Lawful venues for filing. 1. County Recorder's Office. 2. Secretary of State. 3. Universal Postal Union. 4. Online blockchain ledger or public repository. 5. Ecclesiastical record custodian or international tribunal registry. These filings create a lawful chain of title and rebut all presumptions of death, corporate personhood, agency, or voluntary servitude. C. Form and process of filing. 1. Notarization provides third-party witness and authenticates the identity of the declarant. 2. Testimony in the form of an affidavit format must include O name, address, living man-woman capacity, O statement of facts, rebuttal of presumptions, O law cited, O declaration under penalty of perjury. 3. Mailing and service, O certified mail with return receipt, O service to public officials, agents, and trustees, O retain proof of service and UPU timestamp if applicable. D. Finality and binding nature. Once unrebutted, declaration becomes law between the parties UCC. It creates estoppel by acquiescence. It legally blocks any future presumption of O U.S. citizenship when in corporate agency DEG, administrative jurisdiction, O consent to trust administration, O executor de sun tort appointments, ecclesiastical deed poll and divine standing of the living man, woman. A. Nature and authority of the ecclesiastical deed poll. An ecclesiastical deed poll is not a common commercial document. It is an act of divine will, a unilateral ecclesiastical instrument created and proclaimed by a living man or woman who is competent, conscious, and standing in their full divine capacity. Its purpose is 1. To publicly record the living soul's reversion from presumed death to life in the land of the living. 2. To assert absolute ownership of the name, estate, titles, and rights presumed abandoned or bonded under the global trust system. 3. To serve as a superior instrument in ecclesiastical and commercial law, creating lawful notice to all lesser jurisdictions, offices, and agents. The authority behind such an instrument arises not from any statute or charter, but from natural law, divine law, and first claim of use and ownership, as the original source of energy, intention, and title. B. Establishing absolute priority claim to standing and estate. By issuing the notice to cease and desist all administrative bonding in the form and structure of an ecclesiastical deed poll, the undersigned 1. Reclaims absolute legal and equitable title over all derivatives of their name. 2. Denies and rebuts all presumptions of abandonment, incompetency, or commercial suretyship established through registration schemes. 3. Reasserts first in time, first in right claim to the vessel, estate, and body, as well as to any and all energy extracted through illegal bonding, securitization, or monetization, adhesion contracts, commercial statutes, or presumptive, incestuique trusts, municipal franchises and IMF-controlled bonds, U.S. citizen designations or 14th Amendment personhood, unclerical or corporate ecclesiastical registration of the soul. C. Divine and canonical enforcement. This instrument invokes higher standing under canon law, particularly Canon 2057, prohibiting enforcement of foreign presumptions of death, surety, or incompetence. Canon 1441, establishing divine jurisdiction over fraudulent ecclesiastical authority. The original papal trusts, being Unum Sanctum, Romanus Pontifex, and Aeterni Regis, which this deed poll rebukes as fraudulent claims of dominion over the living. Natural law, as expressed through the living, breathing soul endowed with unalienable rights by the Creator. D. Ecclesiastical estoppel and permanent bar. Once this ecclesiastical deed poll, notice is served and entered into the record, and any and all agents, officers, courts, or entities acting against it are in estoppel, having been duly notified and given opportunity to rebut. Failure to respond in kind constitutes tacit agreement and commercial default. All bonds, securities, or financial instruments issued under the name become null, void, and subject to redemption by the living claimant. E. Closing declaration. By this sacred act, I do stand as the first, highest, and final claimant to the body, soul, mind, estate, and name, having come into full knowledge and restoration. Let no man, person, agency, or principality move against this claim, lest they trespass against the living and the divine. Closing decree and reservation of rights. This section finalizes the notice, rebuttal, and declaration of status by asserting supreme claim to all rights, estates, titles, and interests, spiritually, legally, and commercially, and places all parties on permanent notice under international law, canon law, common law, and equity. A. Declaration of living status and ecclesiastical reversion. I, the undersigned living man, woman, having come forward in good conscience and clean hands, do hereby 1. Reclaim my status as a living soul, competent and present, not dead, lost at sea, missing, incompetent, a minor, surety, ward, or debtor. 2. Rebut all prior presumptions created by registrations, licenses, birth records, baptisms, contracts, oaths, securities, or presumed fiduciary relationships. 3. Reclaim all titles, trusts, entitlements, and estates held under cestuique v. constructive, implied, express, or testamentary trusts, whether ecclesiastical, municipal, or commercial. B. Permanent reservation of rights. Pursuant to UCC 1-308, on Canon 2057, 2058, 2059, and Treaty Law and Geneva Conventions, maxims of equity, and the original organic Constitution, I hereby reserve all unalienable rights, including 1. Right to due process under natural and common law. 2. Right to be free from compelled performance or administrative jurisdiction without consent. 3. Right to own property absolutely and hold title free of lien or levy. 4. Right to seek lawful remedy and equity in a competent forum. 5. Right to self-determination and peaceful assembly as a free man-woman. C. Permanent non-consent and prohibition. Let it be known Any further attempts to bond, securitize, presume jurisdiction, administer trust, or treat this living soul as a legal fiction without full disclosure and voluntary wedding consent constitute treason under the organic constitution, o constructive fraud, inequity, o violation of international treaties, spiritual trespass, and ecclesiastical usurpation. D. Lawful remedy invoked. This declaration invokes lawful standing in Article 3 judicial power and common law jurisdiction in divine and ecclesiastical law, private international law, and is made for the record under full liability and penalty of perjury by a living man, woman, with sovereign intent and peaceful purpose, without adhesion, submission, or waiver of rights. E. Authentication. By improper persons sui juris without the United States without prejudice UCC 1-308, all rights reserved. Notary, witness, ecclesiastical deed poll. Divine reclamation of estate, status, and standing under natural and canon law. From the living soul known as, of the house one of the people, standing upon the land under divine law. Date, location. I. Introduction and divine witness. Let it be known to all men and women, persons, agents, trustees, officers and corporations, both domestic and foreign, terrestrial and ecclesiastical. I, the living man, woman known as, being of sound mind, living body, and awakened spirit, do come now in this sacred and solemn act before all creation and under divine witness, to issue this ecclesiastical deed poll, a unilateral, irrevocable proclamation and notice of reclamation. This sacred deed is recorded to correct all commercial presumption, to rescind all unlawful bonds, and to reclaim all property, rights, name, and estate presumed abandoned, securitized, or administered by foreign ecclesiastical or commercial authority. Second claim of status. I now declare and affirm before all creation and law. 1. I am not dead, lost at sea, incompetent, minor, nor abandoned. 2. I am not a U.S. citizen, statutory person, corporation, surety, trustee, debtor, franchise, or artificial entity. 3. I am not subject to the jurisdiction of private administrative courts, nor any foreign ecclesiastical corporation such as the Crown, the City of London, the Vatican, or their bar guilds. 4. I rebut and rescind all adhesion contracts, unconscionable presumptions, and unrevealed trusts executed without full knowledge and consent. 5. I now stand as the living man, woman, holder in due course, executor, and beneficiary of my proper estate, mind, body, and soul. Third rebuttal of ecclesiastical and commercial claims. This ecclesiastical deed poll rebukes and renders void on all presumptions created through the Sestuicavi Acts. All papal claims under Unum Sanctum, Romanus Pontifex, and Aeterni Regis. All bonding instruments created via birth certificate registration, maritime liens, baptismal contracts, and any presumed conveyance of the soul. Any claim under canon law which violates the rights of the living, particularly Canon 2057, which bars false presumption of death or surety without proof. Fourth lawful remedy and divine standing. 1. I hereby serve notice to cease and desist all administrative bonding, as previously declared. 2. I now reclaim all legal, equitable, and divine title to the following: my name in all forms and derivations, my estate in all commercial, national, and ecclesiastical, my body, mind, and soul as indivisible property of the Creator and myself alone, in all trusts, securities, bonds, accounts, and registrations associated with my living estate. 3. I stand under the highest law, natural law, divine law, and unalienable rights as endowed by the Creator. Fifth, ecclesiastical estoppel and default. From the moment this deed is served or recorded, any agent, person, or entity who fails to rebut this claim point for point within 21 days shall be forever estopped from raising objections or exercising presumption. Silence shall be deemed tacit agreement and admission of fraud, triggering full commercial and spiritual liability. This deed poll is absolute in jurisdiction, superior to all inferior courts, and permanent in nature. Sixth record and seal. I do affix my living autograph, seal, and fingerprint as sacred witness to this act of the House. Optional right thumbprint. Date of issuance, location, tips. To maximize the impact and enforcement of your ecclesiastical deed poll and notice to cease and desist all administrative bonding, you should send it to key entities involved in administrative presumption, bonding, and record-keeping, both at the local, state, national, and international levels. Here's a structured list of where and to whom you should send it. County and state record offices. These are your first line of record to establish lawful notice. 1. County Recorder's Office. File the original ecclesiastical deed poll for public record. 2. County Clerk of Court serve the deed poll and notice as a counter-record against any administrative or judicial presumption. 3. State Secretary of State, particularly the UCC division, to create a public notice of claim under commercial registry. 4. County Sheriff, notify the Chief Peace Officer that you are a living man-woman standing in your proper jurisdiction. 2nd Judicial and Administrative Offices. 1. Clerk of the Court. Ensure that any court system where a presumption might arise is on notice. 2. Chief Judge. Presiding Judge of District or Circuit Court. Put the judiciary on notice that you are not a corporate person or subject to administrative jurisdiction. 3. State Supreme Court Clerk, for higher-level rebuttal of presumption across the state judicial system. 3rd Bar Associations and Legal Guilds. 1. State Bar Association. Serve them notice that they are administrating trusts without authority or standing. 2. American Bar Association, especially if using the Bar Treaty of 1947 and related evidentiary filings. 3. Crown Bar, Inns of Court, if referencing ecclesiastical and international bonding. 4th Federal and international authorities. 1. U.S. Secretary of the Treasury, since bonding and monetization of birth certificates is managed under this office. 2. Attorney General of the United States, holds fiduciary responsibility over lawful processes and fiduciary infractions. 3. U.S. Department of State, Legal Affairs, especially if rebutting international presumption or foreign registration. 4. Pope Francis, Holy See, Vatican Apostolic Nunciature in Washington, D.C., if rebutting ecclesiastical jurisdiction, canon law, or unam sanctum. 5. Office of the High Commissioner for Human Rights, if asserting international rights and rebutting human trafficking via bonding. 1. Federal Reserve Bank, if your birth bond or CUSIP-related asset is monetized through Federal Reserve channels. 2. DTCC, holds most securities tied to citizen bonding. 3. IRS Commissioner, as presumed administrator over commercial estate fiduciary matters. Social Security Administration, Legal Department, if asserting that the SSN is tied to a presumed commercial trust. 6th optional but strategic serves. 1. Archbishop of the Archdiocese where you live, if rebutting canon law jurisdiction and seeking ecclesiastical record entry. 2. U.S. Marshal's Office, if invoking federal notice to avoid unlawful arrest, enforcement, or detainment. 3. Bureau of Vital Statistics, where your birth certificate was issued. Include a demand for cessation of all bonding and commercial trafficking of your record. Important tip on format. Always send documents. With certified mail, return receipt. One is stamped private and confidential, with a cover letter identifying it as a matter of superior jurisdiction and lawful authority. Optionally notarized or accompanied by in testimony of service.